Welcome to the Deep Dive. We're the show that digs into stacks of sources to pull out, well, the really key insights and knowledge, hopefully with enough interesting bits to keep you listening. Today, we're asking a question that's pretty fundamental to how our whole justice system works. What actually counts as proof inside a courtroom? How do judges and juries figure out what evidence they're even allowed to look at when someone's freedom or maybe their money is on the line?
Yeah, it's a really complex area and honestly often misunderstood. So our mission today is to take a deep dive into this fascinating world of evidence law. We're really going to zero in on two critical ideas, relevance and admissibility. The goal is to sort of cut through all the legal jargon and shine a light on how courts decide which facts get to shape a case. It's kind of a shortcut, really, to getting you well-informed on this super important topic.
Absolutely. And we've gone through, foundational legal principles, lots of real-world case examples from our sources, trying to map out how courts actually do this painstaking work of piecing together what happened. So let's get into it. Where do we start?
Okay, so the starting point, the very foundation, really, is a concept called res gestae.
Yeah.
It's Latin. Yeah.
Right.
And it just means the thing's done. Simple as that. Think of it as everything happening immediately around an event. The actions, what people said, the circumstances that are so tightly connected to the main thing being disputed, that they're seen as part of that same single transaction.
Okay, so like an unedited snapshot of the moment.
Exactly. It's about facts that are basically part of the event, not something separate, not an afterthought, the immediate context.
Makes sense.
And this idea, it's baked right into our evidence laws. It allows courts to admit facts that are, fundamentally linked to the main event. The key principle here is immediacy, connection, spontaneity. If it's part of that unfolding moment, it's generally in.
Can you give us an example, maybe one that kind of highlights how this works in practice, maybe even surprisingly?
Sure. There's a classic case, R.V. Kurji, from back in 1940. So the accused had just stabbed someone, the deceased's brother. Immediately after that, like right away, he was seen standing over the deceased, holding a dagger. Now, the court said these two things, stabbing the brother, then standing over the deceased, were so interconnected, so close in time and action, that the first act, stabbing the brother, even though technically it could be seen as a separate crime, was considered part of the res gestae in the murder trial for the deceased. It was allowed in because it was part of that single, continuous unfolding story.
Wow. Okay, so even if it points to another potential crime, if it's that tightly woven into the main event, it can be admitted. That seems, well, pretty powerful for painting the full picture.
It is. But there's definitely a line. It's not just anything that happens nearby.
Right. There must be cases where it doesn't apply.
Oh, absolutely.
Yeah.
For a really clear contrast, look at a case called Oriental Fire and General Assurance, Ltd. v. Uganda and others from 1969. This was about a car accident.
Okay.
And statements were made, but they were made after the accident happened. Some time had passed. The court decided these were not part of the res gestae. And the crucial takeaway there is timing and spontaneity. The statement has to be made at the time of the event or, immediately after. It has to show that spontaneous reaction, a direct response, with basically no time for the person to stop, think, maybe cook up a story.
That makes perfect sense. You can't have someone crafting an account later and then try to pass it off as part of the immediate things done. Okay, so res gestae sets that initial bar, proximity, connection, but surely relevance goes beyond just those immediate moments. Courts need to build a bigger picture, don't they?
They absolutely do. And that's where the law kind of broadens out our idea of what's relevant beyond that immediate snapshot. How does a court piece together the whole story from bits and pieces that might not have happened all at the same second? This is where other parts of our evidence laws kick in, letting judges connect dots that maybe aren't obvious right away.
Okay, so we're talking about facts that give context or maybe reveal underlying patterns or motives. What are some of those key categories?
Well, one important area covers facts that form part of the same transaction, even if they happened at different times or places. If they're so connected to the main event that they really form part of the same overall story, the law lets them in, mostly to help explain things.
So it helps build that cohesive narrative.
Exactly, even if parts aren't perfectly simultaneous. It's interesting, actually, how the Kurji case also touches on this. It shows how a sequence of events can be viewed as one continuous transaction, sort of stretching the narrative beyond just the immediate things done.
Right. It's about the logical flow, not just ticking seconds off a clock. And then there are facts about what led up to an event or what happened right after the cause and effect.
Precisely. Section 6 deals with facts which are the occasion, cause, or effect of the main event. Things that set the stage, directly caused it, or were the immediate result. Think of it like the before and after that are naturally linked. These are super important in civil cases, for example, when a court needs to figure out liability, who's responsible, and maybe assess damages.
This makes me think about something you hear about similar offenses. Now, I know usually that's a big no-no, right? You can't just say, oh, he did something similar before, so he must have done this too.
You're right, that's the general rule, and it's a really important protection against prejudice. But there are exceptions.
Okay.
The case John McKinney versus Republic really clarifies this. Generally, evidence showing an accused committed other crimes isn't allowed just to prove they have bad character. But, and this is the key, that evidence is admissible if it's genuinely relevant to an actual issue the court has to decide.
Like what?
For instance, if it helps rebut a specific defense the accused is putting forward, or if it helps show whether the acts were intentional, part of a plan, or just accidental, it has to go beyond just saying, this person does bad things.
And the McKinney case itself is pretty stark, isn't it?
It is. The appellant claimed a boy died tragically from an epileptic seizure and a fall. But the prosecution brought in evidence from 3 witnesses who described a history of the appellant violently beating the boy. Now, that wasn't just to paint him as a bad person. It directly contradicted his defense about the seizure and fall. It showed a pattern of conduct directly relevant to how the boy might have actually died.
So it directly rebutted his specific explanation. Okay, that makes the distinction clearer. What else falls under this broader relevance?
Well, the law also focuses heavily on motive, preparation, and conduct, either before or after the event. Any fact that shows why someone might have done something, their motive, or what steps they took beforehand, their preparation, is considered highly relevant.
Understanding the lead-up, the why, can be crucial. I remember the case of Musana Alex versus Uganda really illustrating the preparation point.
Oh, absolutely. In that case, the appellant's actions, things like following the deceased woman, calling her his girlfriend even though she was married, buying her beer, the prosecution used all that conduct to convince the court he was, and I'm quoting roughly here, preparing for his chance to be alone with the deceased, to fulfill his lustful desires. It really shows how powerful evidence of preparatory conduct can be in building a picture of intent.
That's compelling. And then there's a whole category about facts that explain things, introduce ideas, support inferences, establish identity, time, place, relationships. That sounds like a really broad umbrella.
And it's quite broad, covering Section 8. Think about facts which support or rebut an inference. Evidence can strengthen a presumption like, say, you're the only person with keys to a locked room where a crime happened. That creates a strong inference.
Right.
Or it can powerfully rebut an inference, like having a completely solid alibi. This area often involves circumstantial evidence, which has a really high standard.
Yeah, like in Uganda v. Richard Baguma, the court said circumstantial facts have to be, what was it? Incompatible with the innocence of the accused and incapable of explanation upon any other hypothesis than that of guilt. That's a seriously high bar.
It is. Extremely high. Then, under that same umbrella, you have the whole complex business of establishing identity. When someone identifies an accused, courts look really closely at several things.
Right.
Well, how well did the witness actually see the person? Did they form a clear, settled mental impression? Was their memory potentially tainted by suggestions from other people? Was there enough time, enough light, enough opportunity? And does the identification seem reliable given all the circumstances?
Voice identification must be particularly tricky, though. It's not like seeing someone's face. It feels much more subjective.
It's incredibly difficult, and courts treat it with, and this is the phrase used, the greatest caution, that came up in Shoma and another VR, especially if the witness only heard the person and never actually saw them speak. It really raises a question for you, listening at home. Just how reliable is our memory for voices, especially maybe under stress? It really makes you think, doesn't it?
It absolutely does. And for visual identification, to avoid mistakes, they have these formal procedures like identification parades.
Yes, exactly. And the rules for those are quite detailed, as laid out in cases like Uganda v. Ntambazi. For example, the people standing in the parade need to be reasonably similar in appearance to the suspect, not identical clones, but similar build, age, race, etc.
Right.
And critically, the witness shouldn't see the accused before the parade happens, like in the waiting room or something. And everything needs to be strictly recorded. It really shows the effort courts put into preventing tragic cases of mistaken identity.
That meticulousness is so important for fairness. Okay, shifting gears a bit, let's talk about common intention, especially in conspiracies. How does what one person does in a group end up being relevant for everyone involved?
Right. Section 9 covers this. Once it's established that two or more people had a common intention, basically an agreement or plan to commit an offense or do something wrong, then anything said, done, or written by any one of them in furtherance of that plan becomes relevant evidence against all of them.
So the agreement is key.
Yes. The crime, in a sense, starts the moment they agree on that common purpose. It means you don't necessarily have to be the one who physically did the final act if you were part of the shared plan from the beginning.
So even if you didn't, say, throw the punch, your words or earlier actions showing you were part of the plan can be used against you. The Mugai case had a powerful example of this, didn't it?
It really did. Mugai and 8 other Jirongo versus Uganda. During an assault by the group, one of the appellants actually shouted out something like, "Beat them, I will face the case."
Wow.
The court used that specific statement as strong evidence that all the appellants knew they were doing something illegal and were acting together with that common intention. His words sealed the deal for the group's shared responsibility.
Okay. Then we have Section 10, facts that are contradictory or inconsistent. How do courts handle it when a witness says one thing, then maybe seems to say something slightly different later?
Yeah, witness testimony is rarely perfectly consistent. Uganda v. Nasur helps clarify this. The court distinguishes between grave inconsistencies, really fundamental contradictions on key points that the witness can't explain away.
Right.
Those can lead to the court rejecting that witness's evidence entirely. But then there are minor inconsistencies, small discrepancies on less important details. Generally, those don't automatically discredit the testimony unless they seem to indicate the witness is deliberately lying or making the whole thing up. It's a nuanced view, acknowledging that human memory isn't like a video recording.
That's a really important practical distinction for weighing reliability. Okay, and finally, in this broad relevance section, we have facts showing a person's state of mind or even bodily feeling, Section 13.
Exactly. This covers facts that reveal someone's internal state, things like their intention, their knowledge or lack of it, whether they acted in good faith, were negligent, or even things like their physical health or feelings. If those internal states are actually relevant to a fact the court needs to decide. For example, if someone made threats before an assault, that clearly shows an intention to cause harm.
And this is where we get that really striking example of how patterns can become evidence, even patterns of seemingly separate events. I'm thinking of the Republic versus Smith case.
Yes, a truly chilling case. In Smith, the accused claimed his wife drowned in the bathtub due to an epileptic seizure.
Okay.
But the prosecution introduced evidence that, remarkably, other wives of the same accused had also died in bathtubs in similar circumstances in the past.
What?
Now, this wasn't admitted just to say, look, he's done this before. It was admitted as evidence relevant to his state of mind. It tended to show intention in the current wife's death, or at least to strongly negate his claim that it was just a tragic accident. The sheer improbability of that pattern occurring by chance was key to understanding his likely intent.
Okay, let's shift gears now. Let's talk about confessions. Huge topic. What exactly counts as a confession in the eyes of the law? It seems simple, but I bet it's specific.
It is very specific. Foundational cases like Swami v. King Emperor and Uganda v. Mutahanzo tell us a confession has to be an unequivocal, meaning clear and unambiguous admission of guilt. Or it could be an admission of facts that pretty much add up to the crime itself.
So it can't be vague or just admitting part of it.
Exactly. And crucially, as Inyanga VR established, a statement isn't legally a confession unless it's enough all by itself to justify convicting the person who made it. It has to be a full admission, essentially.
That's a high standard. And who is actually allowed to take down a confession? Has that changed over time?
Oh, it's changed significantly.
Yeah.
It really reflects a growing focus on protecting the rights of the accused. Years ago, even a police corporal could take one.
Really?
Yeah. Then the rules tightened, requiring a magistrate to be present for certain serious cases. And now, the law specifies it must be a police officer at or above the rank of assistant inspector of police.
Okay.
And, importantly, a conviction based only on such a confession generally needs corroboration. Now I'm meaning some other independent evidence has to support it.
So if, say, a regular police constable takes down what seems like a confession.
It's inadmissible. Simple as that.
Okay.
The case Waswa v. Uganda made this very clear. A confession recorded by an officer below the rank of assistant inspector was thrown out because it didn't meet the Evidence Act's requirements.
Wow, okay, so that makes the question of whether the confession was voluntary absolutely critical then. Was the person speaking freely, or were they pressured? This feels like the heart of the issue with confessions.
It's the absolute core issue, yes. For a confession to be admissible, it must have been made voluntarily. That means free from any threat, any promise or inducement, or any violence.
Can you give an example of inducement?
Sure. R.V. Okello is a classic cautionary tale. The accused was told something like, just confess and your punishment will be light. That sounds maybe like helpful advice, but legally?
It's an inducement.
Exactly. It's seen as an improper inducement coming from someone in authority, so the confession that followed was ruled inadmissible.
Okay, that's pretty clear cut. But what if the idea, say, for getting bail in exchange for a statement actually comes from the accused person first? Can that still make the confession involuntary? This seems subtle.
This is where it gets really interesting and maybe surprising for listeners. Look at R.V. Zavekas. The accused himself asked the police officer, hey, if I make a statement, will you give me bail right now? And the officer said yes.
Okay, so the accused initiated it.
He did. But the confession that resulted was still ruled inadmissible. Why? Because it was made as a direct result of that promise, that inducement of getting bail. Even though the idea came from the accused, the officer's agreement created the improper link, making the confession involuntary.
That is a surprising detail. It shows just how careful courts have to be about any hint of pressure or promise surrounding a confession.
Absolutely. But, courts also exercise discretion. In another case, Arakanjiro Dao VR, there was a statement that could have been seen as a threat, but the court found it was sort of tempered by the words that followed. Basically, the overall context didn't amount to an illegal inducement, so the confession was allowed in. It's not always black and white.
Right. Now, what about some of those other surprising situations where a confession might still be considered relevant, even if the circumstances seem a bit off?
Yeah, Section 26 lays out some interesting ones. A confession that's otherwise relevant doesn't suddenly become irrelevant just because, say, it was made under a promise of secrecy, or because some kind of deception was practiced on the accused to get it, or even if the accused was drunk when they made it, or, importantly, even if they weren't given the formal warning that anything they say might be used against them.
Wow. Those really do challenge common assumptions.
It is.
It suggests the law is sometimes more focused on the potential truth of the statement itself rather than every single detail of how it was obtained.
That's a good way to put it. It's a pragmatic approach in some ways.
Huh.
Now, we also need to distinguish between retracted and repudiated confessions. People often mix these up.
Yeah, they sound similar. What's the difference?
Okay, so a repudiated confession is when the accused completely denies ever making the statement at all. They're saying, I never said that. It's fabricated.
Got it.
A retracted confession is different. Here, the accused admits, yes, I made that statement, but now they're taking it back, saying it wasn't true or wasn't voluntary. Maybe they claim they were forced or tricked into saying it. This kind of challenge is, unfortunately, quite common in some systems, often raising questions about how confessions were originally obtained.
So if a confession is retracted or repudiated, does the court just ignore it then?
Not automatically, but it triggers what's called a rule of prudence, highlighted in Tuamwe v. Uganda. Courts have to be extremely cautious. They should always look for corroboration, that independent supporting evidence we talked about, or at the very least be absolutely fully satisfied about its truth before they rely on that confession, especially given the possibility of issues with how it was extracted. It puts up a very high barrier for reliance.
Okay. And what about when one person confesses and it implicates someone else who's being tried alongside them in a joint trial? That sounds like a minefield for fairness.
It is tricky. Under Section 27, a confession made by one person being tried jointly can be taken into consideration against a co-accused. However, the law views this as generally the weakest kind of evidence.
Weakest kind? Why?
Because the co-accused hasn't had the chance to cross-examine the person who made the confession about that statement. The critical test is, the confession must fully incriminate the person who made it. And it shouldn't just be an attempt to shift the blame onto the co-accused. It's a really important safeguard in joint trials.
Yeah, maintaining fairness there seems paramount. Okay, one last thing on confessions, this idea of information leading to discovery. Section 29. This sounds intriguing.
It's a fascinating and very practical exception. Here's the gist. Even if a confession itself is inadmissible, maybe because it was involuntary, forced out of someone, if part of that inadmissible statement provides information that distinctly leads the police to discover a relevant fact.
Like finding the murder weapon. Or the body.
Exactly, like finding a weapon or stolen goods or a body. That specific part of the statement, the bit that directly led to the discovery, can still be proved in court.
So, let me get this straight. The confession saying, "I killed him," might be thrown out if it was forced. But if that same forced confession included, "I hid the knife under the oak tree," and the police go there and find the knife, the part about the knife's location is admissible.
Precisely. The case Birembo v. Uganda illustrated this perfectly. Information from the appellant, likely within a problematic confession, led directly to finding a body and some money. That specific information about the location was admissible, even if the broader confession wasn't. It's a balance, right? Excluding the coerced statement itself, but allowing concrete, verifiable evidence discovered because of it.
That really shows the court's trying to balance protecting rights with finding the truth. Okay, let's tackle our big one now, the evidence that often doesn't get in. Hearsay. What exactly is it, and why the general ban? It seems natural to just ask someone what they heard someone else say.
Yeah, it seems logical, but the law says, hold on. Hearsay is basically secondhand evidence. It's when a witness in court testifies about a statement made by someone else outside of court, and that testimony is offered to prove that the content of the out-of-court statement is actually true.
So it's not just reporting that the statement was made, but trying to use it to prove the truth of what was said.
Exactly. It's not original evidence. The fundamental rule, Section 59, is that oral evidence must be direct. The witness testifying must have personally seen, heard, or perceived with their own senses the fact they're talking about.
Okay, so if I testify, my neighbor told me the getaway car was blue. That's hearsay if we're trying to prove the car was actually blue. The court wants to hear from the neighbor directly.
Precisely. And the reasons for excluding hearsay are really compelling, rooted in fairness and reliability. Think about it. That out-of-court statement wasn't made under oath. The person who actually made the statement isn't there to be cross-examined. The lawyers can't question them about what they said, why they said it, their perception. We, the judge or jury, can't observe their demeanor. Were they nervous, confident, shifty? There's also a real risk of error in transmission, like a game of telephone. The story might change as it's passed along. And fundamentally, it's about fairness to the party the evidence is being used against. They have a right to confront their accusers, to challenge the evidence directly.
The Sparks v. R case is often cited here, isn't it? It's quite a sad example.
It is. In Sparks, a mother testified about what her very young child, who wasn't called as a witness herself, had said about identifying the person who assaulted her. The court ruled that mother's testimony was inadmissible hearsay. Even though it was about identification, the crucial statement came from the child outside of court, and the defense couldn't cross-examine the child. It's heartbreaking, but legally it follows the rule.
So the rule is strong. But does that mean no hearsay ever gets in? Couldn't that sometimes lead to injustice if the only evidence available is something someone said who maybe isn't available anymore?
That's exactly the point. A complete, rigid ban on all hearsay would lead to injustice in some cases. So the law recognizes necessary exceptions. These exceptions exist because sometimes certain types of hearsay are considered inherently more reliable, or they're simply essential to get to the truth.
Okay, so what are some of the main exceptions people should know about?
Well, a big category involves statements made by people who are now unavailable to testify. This could be because the person is deceased, or they genuinely cannot be found after diligent search, or they become incapable of giving evidence, maybe due to illness, or bringing them to court would cause unreasonable delay or expense.
And probably the most famous, or maybe infamous of these, is the dying declaration, right? We see it in movies all the time. What makes it admissible?
Right, the dying declaration, Section 30A. For this to apply, the statement has to be about the cause of the person's death, or the circumstances surrounding the event that led to their death. And crucially, it must be made when the person is under the settled expectation of death, meaning they genuinely believe they are dying and have no hope of recovery.
So it's not just any statement made before dying, but made with that specific solemn belief. The idea being people don't lie when they think they're about to meet their maker.
That's the traditional rationale, yes. But even then, caution is required. Is corroboration needed to actually convict someone based only on a dying declaration?
Good question.
Yes, it generally is. The case Uganda v. Alfredo Yaka stressed this. A conviction based solely on a dying declaration really needs satisfactory corroboration. Some other independent evidence needs to back it up. In that particular case, medical evidence showing injuries consistent with the deceased's statement provided that crucial corroboration.
Okay, so corroboration is key. Now, what if Say 3 different people heard the dying person make the same statement. Does having multiple witnesses repeating the declaration count as corroboration? It kind of feels like it should, right? More people heard it.
This is a classic point of confusion and a real aha moment for understanding corroboration. The case Kalisti Sibugwawo v. Uganda made it very clear. Simply having multiple witnesses repeat the same dying declaration is not enough corroboration.
Really? Why not?
Because they all heard it from the same single source, the dying person. It doesn't provide independent support for the truth of the statement itself. You still need something else, some different piece of evidence entirely to back it up. Repetition isn't verification.
Wow, okay. That's a crucial distinction. It's about independent proof, not just more echoes of the same claim. What about the timing? How close to the actual death does the statement need to be?
There needs to be a proximate relationship, as established in Baruga VR. The statement has to be closely connected to the circumstances of the death. Just a general fear of dying someday or a statement made long before the fatal event wouldn't qualify. It needs that direct link.
Okay. What are some other key hearsay exceptions?
Another important one is statements made in the ordinary course of business. Think about regular business records, entries in ledgers, memos written as part of the day-to-day operations. If these were made routinely as part of normal business, and this is important before any legal dispute about the matter even started, ante litem motem.
Right, so not created specifically for the lawsuit.
Exactly. Then they're generally considered reliable and admissible. The lack of motive to falsify at the time they were created gives them credibility.
That makes sense. Routine records are usually trustworthy. What else?
Then there are statements against pecuniary or proprietary interest, Section 30C. Basically, statements made by someone that go against their own financial interests, like admitting they owe a debt, or their property interests, like saying a piece of land isn't actually theirs.
Or even admitting to a crime.
Yes, or statements that would expose them to criminal prosecution or civil lawsuits. The thinking here is people generally don't make false statements that harm their own interests, so if they do, it's likely true.
Okay. And there are also exceptions for things like public rights and family relationships.
Briefly, yes. Statements about public rights or customs or about family relationships, pedigree, are also exceptions, usually requiring the statement was made before any controversy arose about that right or relationship.
Got it. Okay, so we've navigated the tricky waters of hearsay and its exceptions. Now let's turn to opinions and character evidence. Generally, courts want facts, not opinions, right?
That's the general rule, absolutely. A witness is usually there to state facts they observed, not to give their personal opinion or draw inferences from those facts. The judge or jury is supposed to do the inferring and opining based on the evidence presented.
But there's a huge exception. Expert opinion. How does the law define an expert, and how much weight does their opinion carry?
Right. Section 43 covers experts. An expert is someone considered specially skilled in a specific field, things like foreign law, science, art, identifying handwriting or comparing finger impressions. And importantly, expertise isn't just about academic qualifications. As R.V. Oakley showed, it can include skill acquired by practical experience.
Like the police officer in that case with years of accident investigation experience.
Exactly. 15 years investigating traffic accidents made him an expert in that specific area, even without a fancy science degree in physics.
So knowledge and experience count. But is the expert's opinion binding? Does the court have to accept what the expert says?
No, definitely not. Expert evidence is there to assist the court, not to dictate the outcome. The court has to evaluate it carefully, consider the expert's reasoning and qualifications, and can ultimately accept or reject it. However, if the court does reject expert opinion, especially if it's uncontradicted, it needs to provide proper and cogent reasons for doing so, as per D'Souza v. Sharma.
So the why behind the opinion matters too.
Yes, Section 49 makes it clear that the grounds on which an expert forms their opinion are also relevant and can be examined. It's not just the conclusion, but the process.
And sometimes that expert opinion is absolutely necessary because the topic is just too specialized for a regular person, right?
Precisely. Take R.V. Smith again, the bathtub case. The defense involved automatism sleepwalking. The court said the psychiatrist's expert evidence on this was relevant and necessary because automatism is simply outside the experience of the ordinary layperson. Without the experts, the jury wouldn't have the tools to properly evaluate that defense. It's a great example of why we need experts to explain complex issues.
Okay, that makes sense. Now let's talk about character evidence. This is another area where the rules seem quite strict, especially about bringing up someone's past crimes.
Very strict, and for good reason preventing prejudice. The general rule, Section 54, is that evidence about character should relate to a person's general reputation or disposition, not specific past actions used to prove they likely acted that way again.
So Section 52B usually forbids the prosecution from just bringing up old convictions.
Correct. The prosecution generally cannot introduce evidence of previous convictions just to argue, look, this person has a criminal record, they're a bad character, so they probably committed this crime too. That's seen as fundamentally unfair. The focus must be on the evidence for a current charge.
But like with other rules, there must be exceptions. When can previous offenses be brought up?
Yes, there's a critical exception. Previous offenses are admissible if they're directly relevant to an issue the court has to decide in the current case. Things like proving a specific design or plan, negating a defense of accident or mistake, or showing a specific intent.
Like in the Rodley case.
Exactly. In Rodley, the accused was charged with breaking into a house with intent to rape. Evidence that he had broken into another woman's house earlier the same morning was admitted. Why? Not just to show he was generally breaking into houses, but specifically to prove his intent during the first break-in was likely sexual assault, rebutting any innocent explanation he might offer. It went to a specific element of the charge.
So again, it's not bad person did bad thing, but this past act sheds light on the specific question of intent or design in this case. Okay. Now, what happens if the accused person goes on the attack and makes accusations against the prosecution witnesses or the complainant? Does that change things?
It certainly can.
Yeah.
It's often referred to as opening the door. If an accused person, as part of their defense, makes imputations on the character of the complainant or prosecution witnesses, basically, accuses them of lying, fabricating evidence, or being disreputable themselves, they run the risk
of having their own character brought into question.
Precisely. The prosecution might then be allowed to introduce evidence of the accused's own bad character, including previous convictions, to counteract those imputations.
So there's a real tactical tightrope to walk in presenting a defense.
Absolutely. The case Abdullah Katwe VR shows this line. The defense suggested the police had fabricated evidence by planting stones in the accused's car. The court decided this went beyond what was necessary for the proper and fair presentation of their defense. It was a direct attack on police integrity.
And that allowed?
It allowed the prosecution to cross-examine the accused about their own previous convictions. It demonstrates that fine line between strongly denying the evidence against you and launching an attack that opens you up to character evidence yourself.
Okay, one last point on character. What if one accused person gives evidence that implicates a co-accused being tried alongside them?
This is covered in Section 52 Tech. If an accused person gives evidence against another person charged with the same offense in that trial, then evidence of the first accused's bad character, the one giving the evidence, becomes admissible.
So, trying to help yourself by pointing the finger at your co-defendant can backfire by allowing your own past to be brought up. How exactly is evidence against defined here? It seems crucial.
It is crucial. The principles were laid out in Murdoch v. Taylor. Evidence against means testimony that either supports the prosecution's case against the co-accused in a significant way or undermines the co-accused defense. The key is the objective effect of the evidence. What impact does it actually have on the co-accused's case? It doesn't necessarily matter if the first accused intended to harm the other. It's about the impact of their testimony. It really shows how complex defending multiple people in one trial can be.
Wow. What an incredible journey through these rules. We've gone from the immediate things done of res gestae through all the ways context and patterns become relevant, wrestled with confessions and their voluntariness, navigated the maze of hearsay exceptions, and looked at opinions and character. It's a lot, but it's clear these rules aren't just random obstacles. They seem meticulously designed, really, to ensure fairness and reliability in this difficult process of finding truth in court.
Indeed. And understanding these core principles, even just the basics we've touched on, is so key if you want to be genuinely well-informed about how our justice system actually functions. It lets you look past the dramatic headlines and start to appreciate the intricate mechanics of how proof is actually established, tested, and ultimately weighed. It's about the process, not just the outcome.
Absolutely. So as we wrap up this deep dive, maybe here's a final thought for you, our listener, to chew on. Given these really strict rules, these nuanced interpretations of what's actually allowed as evidence in court, how much of what we generally accept as truth in our everyday lives, based on stuff we hear, things people tell us, gut feelings, how much of that would actually survive this kind of rigorous legal scrutiny? And what does that difference tell us about the very nature of proof itself, both inside and outside the courtroom?